Ken Riley. He is with the law firm of Farris, Riley and Pitt. He's here to explain a sneaky contract clause. Is that right?
Well, you could call it sneaky. It's less sneaky nowadays because it's so common. This is called binding arbitration, or an arbitration clause. And what an arbitration clause is, it's a clause, or it's some language that's found in a lot of times consumer contracts, or as we see a lot of it nowadays, in nursing home contracts. When you admit a loved one into the nursing home, a lot of times you're signing on behalf of that person because they're unable to. Well, when you do that, you're also likely signing an arbitration clause. So what does that mean? Well, it means if there's some mistreatment, for example, in that situation, there is no right to a jury trial. There is no right to have a peer of folks in your group of folks in your community to actually judge the type of conduct that went on. There's no right to an appeal in most circumstances. And also, like we talked about, it's usually hidden in the fine print. You're just trying to get through the contract and sign it and move on. Now, that doesn't mean that there is not a case. If something has happened to you, if it's in a consumer situation, if it's in an insurance situation, if it's in a nursing home situation, doesn't mean that all is lost. But you do have to go to a lawyer. They do have to go through it, make sure that that clause is valid. If it is valid, then we can do what's called as file in arbitration. Or a lot of times they'll compel arbitration if we just file a case. Well, there's a lot of good arbitrators out there, a lot of fair people that act as judges in these cases. So it doesn't mean that you don't have a case. It just means that you can't have your case looked at by a group of jurors.